Today we're going to be discussing the landmark case U.S. v. Virginia, where the government brought a successful challenge against the all-male admissions policy of the Virginia Military Institute. Part 1. Situating the case. It is important to talk about cases within the historical and legal context that they exist in. We gotta walk through the long and winding road that is the procedural history of the case. So, let's get started. In 1982, 14 years before U.S. v. Virginia came before the Supreme Court, was another decision where the Supreme Court addressed single-sex admissions policy. That case was Mississippi University for Women v. Hogan. The court held in an opinion written by Justice O'Connor that men could not be excluded from admission and study to the traditionally all-female state nursing school. Now, Hogan wasn't the first case where the U.S. Supreme Court used an intermediate standard of review to assess sex-based classifications. I think that was Craig v. Boren in the 70s, but Hogan is also helpful here as it's perhaps the most analogous case to VMI, in that in both, the Supreme Court assessed the constitutionality of a single-sex admissions policy of an institution of higher learning. Underpinning the decision was the court's determination that the school's single-sex admissions policy didn't further any legitimate educational purpose, but instead was based on stereotypes that nursing always has been, and in fact should be regarded as an exclusively female profession. And the court said, sorry, you can't do that. Interestingly, the court did not declare all single-sex education unconstitutional, and in fact, it deliberately left the door open where, in the right circumstances, a single-sex admission policy could withstand judicial review if that justification stemmed from unintentional and direct assistance of members of the sex that is disproportionately burdened. What Justice O'Connor is referencing there is that the use of affirmative remedies like a single-sex admissions policy could be permissible to address gender inequalities if that was the main intention behind establishing that policy in the first place. Now, I had never heard of affirmative action in the context of gender ever before. I didn't know that you could address historical exclusion and lack of opportunities for women by creating intentionally gendered policies. But the Supreme Court had actually already talked about this 10 years earlier in the 1972 case Conn v. Shevin. In Shevin, the court upheld a $500 property tax exemption for widows that didn't exist for widowers in the state of Florida. In that case, Justice Douglas stated, quote, "There can be no dispute that the financial difficulties confronting the lone woman in Florida or in any other state exceed those facing the man, whether from overt discrimination or from the socialization process of a male-dominated culture. The job market is inhospitable to the woman seeking any but the lowest paid jobs." Florida chose to remedy the very real inequality faced by women by enacting this particular gendered statute. And in a 6-3 decision, the Supreme Court said, that's fine. No violation of the 14th Amendment's Equal Protection Clause. Why? Because the differential treatment of genders rests on, quote, some ground of difference having a fair and substantial relation to the object of the legislation, aka it purported to remedy past societal discrimination, which, if you think about it, is actually really forward-thinking logic for a 1972 all-male Supreme Court. We don't have time to really talk about the fact that, well, this law doesn't address the economic disparities of all women relative to all men. Because it's a property tax exemption, it only applies to women owning property. My guess is that, intentional or not, this law addressed the economic disparities, or tried to, between property-owning women who were white and similarly situated property-owning men who were also white. It's likely that lower-class women and women of color were disproportionately excluded from even claiming the $500 property tax exemption in the first place. Our takeaway from Shevin is that the Supreme Court recognized and held constitutional a law based in affirmative action for women. And this is the exact scenario contemplated by Justice O'Connor in Hogan. So to recap, U.S. v. Virginia is being litigated in a legal landscape where A, Intermediate scrutiny is the standard applied to sex-based classifications, and intermediate scrutiny, remember, just means that the discriminatory method chosen needs to be substantially related to the important governmental objective it seeks to achieve. And B, that measures which are facially sex-based could, if the circumstances were right, be held to be constitutional if they purported to remedy past societal discrimination or promote equal employment or offered some other type of affirmative action that would help women. The Virginia Military Institute, VMI, was founded in 1839, and it combined military-style training with education to produce what it called citizen soldiers. VMI's citizen soldiers were set up to be, quote, leaders in their communities ready to come to their country's defense if necessary. Kind of like a well-educated reserve, I guess. It's important to note here that only 15% of VMI's cadets went on to enter career military service. Since its founding, VMI accepted troubled young men and molded them and took pride in molding them into fine young gentlemen. Students called cadets were known as rats their first year, and they were subjected to all kinds of grueling challenges to make them more of a man than they were when they first came onto campus. This model was called the adversative model. The adversative model facilitated the boy-to-man transformation by basically employing the model, we'll tear him down and then we'll build him back up again in the image that we want. Cadets dressed in uniform all the time. They lived in Spartan barracks, which had no privacy. I'm talking no locks on the doors, no blinds on the windows, no curtains in the showers, nothing that would be considered comfort either. So no posters allowed on the wall, no carpet on the floor, because cold feet doth make the man. They had days fully scheduled from 6:30 a.m. to 11 p.m. lights out with classes, military drills, conditioning exercises. Any breaches to the student honor code were met with one penalty: expulsion. Added to this nightmare of a life, I mean, at least to me, some people love it, was this pervasive cultural attitude that women were to be treated as objects of either desire or derision. Now, there were certain ladies which were to be treated with chivalry. Read white Southern belle type women, and also read benign sexism. But within the walls of VMI, everyday language, some of it codified in the Rat Bible, told a bit of a different story about how women were supposedly viewed. Take a phrase like running a period, which meant going 28 days without a demerit, or using the title of dyke to indicate a senior class mentor / torturer extraordinaire who is responsible for what can best be described as intense and regular hazing. Then there were other fun, unofficial phrases like raping your virgin ducks, which meant to peel apart a new and very starchy, fresh new pair of trousers. Or rolling your hay tight as a tampon, which just meant rolling up your thin mattress every morning. And in 1989, the Department of Justice took a look at VMI in all of its everything and said, you know what? This place could use a woman's touch. I jest. So here's what happened. An anonymous female high school student filed a complaint with the DOJ that her application wouldn't even be looked at because she was a woman. And she wasn't alone. In the 2 years preceding litigation, 347 other women had also made inquiries about admission to VMI. All of them were denied. This begs the question, why did the DOJ go after VMI? Well, litigation is all about strategy, and basically the government thought it could collect a W on gender equality. One lawyer who was involved in the litigation later said, although VMI's admission policy might have seemed like a small fish, at least it looked like one that could be shot in a barrel. On the other side of the litigation aisle, Virginia and proponents of VMI's all-male admissions policy basically argued that allowing women into VMI would topple everything that the school stood for, that the rich, storied 150-year tradition of this fine Virginian institution would be literally reduced to rubble, debris, and just memories of how great it used to be before they let those damn women in. Part 3. First crack at the Supreme Court. The first trial of the case in 1990 saw 19 witnesses' testimony and took 6 days. The government argued that VMI could not constitutionally exclude women who could satisfy VMI's requirements for admission, even as it conceded that, not that many women really probably want to go to VMI. Virginia argued that the uniqueness of VMI, the way of life that it advocated, the success of its adversative model as demonstrated by the success of its graduates were all legitimate reasons for maintaining its all-male admissions policy. It also played the classic states' rights argument. It said that the state of Virginia should not have to bend to the heavy hand of the federal government when it, as a sovereign, had the right to choose which educational theories were presented to its citizens within its own borders by state institutions. Besides, Virginia argued, there are benefits to single-sex education, and a ruling for the government would basically make single-sex an endangered or indeed even an extinct species in the future. And Virginia wins. District Court Judge Jackson Kaiser said this in his opinion: VMI truly marches to the beat of a different drummer, and I will permit it to continue to do so. The case goes to the Fourth Circuit Court of Appeals, and this is where Virginia gets stuck a little bit. A really big part of Virginia's argument in favor of the all-male admissions policy was that VMI's adversative model was A, the root of its unique placement in Virginia's educational landscape, and B, that it was fundamentally unsuited for women, and further that women might actually undermine that very same model. But the more that Virginia stressed its uniqueness, the more emphasis it placed on how special the adversative model was, the more it became clear that women were being excluded from something they legitimately couldn't get anywhere else. And Virginia really hunkered down on this argument. And the more that it did, the more that it also became apparent it was actually code for more invidious attitudes of male superiority. Now, the Fourth Circuit did something interesting here. It walked the tightrope a little bit because it agreed with both Virginia and the government. On the one hand, it agreed that single-sex education did in fact offer benefits. It agreed that the adversative model offered advantages to men, and it agreed that opening VMI up to women would necessarily mean that substantive changes needed to happen at VMI. For example, coming up with housing solutions and women's bathrooms. They also said that admitting women might impinge on the diverse options for higher education within the state of Virginia. So it concluded that there were legitimate reasons why VMI had this all-male admissions policy. But then it also agreed with the government in that it was clear that the adversative model offered benefits to men, and it was unclear why those same benefits could not be extended to women as well. The government edges out a win here, and VMI's all-male admissions policy is found to violate the 14th Amendment. After that decision, VMI had a choice. It could A, admit women, B, not admit women but lose all of its state funding, or C, it could establish a parallel program for women. Now, the state of Virginia looked at all of these options and thought, I will not be ordering off of the a la carte menu today. I like none of these options. So it appealed to the Supreme Court, which denied certiorari. Certiorari? Look, it denied cert. I don't actually know how to pronounce that word. In the wake of the Fourth Circuit decision, Virginia pursued the option behind door number 3, and it set about creating a parallel program for women. In 1993, Mary Baldwin College, a all-girls private institution conveniently located a mere 35 miles away from VMI, agreed to develop a program for women with a military-style bent. This program was going to be called the Virginia Women's Institute for Leadership, VWIL, as in We Will Rock You. I'm sorry. VWIL. If this is starting to sound to you like separate but equal, you're not wrong. And in fact, it was promptly challenged in district court in 1994. Presiding over the case, our good friend, Judge Kaiser. Part 4, creation of and challenge to the VWIL. The government's argument was pretty simple. VWIL and VMI were not equal and were actually never intended to be equal. The purpose of VWIL was to produce female citizen soldiers without using the adversative model that made VMI so unique. In fact, VWIL advocated the total opposite approach. Its methodology was supposed to be cooperative and to reinforce self-esteem, to build up, quote, self-confidence through mastery of physical, intellectual, and experiential challenges. The living accommodations would not be Spartan. Their students would be afforded privacy, like locks on doors and blinds on curtains and curtains on showers. Uniforms were only required when students were participating in the largely ceremonial ROTC program held on VMI's campus. There was no crazy hazing as part of the culture. And on top of that, the physical fitness requirements were deemed comparable but notably less demanding than VMI's. And these weren't the only differences that mattered. VWIL students would have far less resources at Mary Baldwin than their male peers at VMI had access to. For example, VWIL students couldn't take classes in engineering, advanced math, or physics because those classes simply didn't exist at Mary Baldwin. Significantly fewer faculty at Mary Baldwin held PhDs when compared to the faculty at VMI. The faculty salaries at Mary Baldwin fell within the bottom 20% of compensation for faculty across the country. VMI's faculty were compensated in the top 8%. The average SAT score of an entering student at Mary Baldwin College was 100 points lower than at VMI, and Mary Baldwin didn't have comparable facilities available. It only had 2 multi-purpose fields and 1 gymnasium for physical training. Meanwhile, VMI had an NCAA competition-level indoor track and field facility, more than 2 multi-purpose fields, baseball, soccer, and lacrosse fields, an obstacle course, large boxing, wrestling, and martial arts facilities, an indoor running course, an indoor pool, indoor and outdoor rifle ranges, and a football stadium with its own practice field and outdoor track. The budgets of the school, not even close. We're talking a difference of hundreds of millions of dollars. And just to top it all off, a degree from VMI meant something. There was built-in prestige to a VMI diploma that Mary Baldwin could never replicate for its VWIL students. That prestige led to better positions for VMI's graduates. In actual fact, VMI alumni were disproportionately influential in the state of Virginia. So, what did the court say? Well, Judge Kaiser, our district court judge, says, I think this is fine. And he got there because the Fourth Circuit had specified creating a, quote, parallel program for women and not an equal one. The case goes back to the Fourth Circuit, and the Fourth Circuit upholds the district court's decision 2-1. Big ups to Judge Phillips for being the lone dissenter. And what Judge Phillips said was, look, the whole argument that VMI offers something that is inherently different, bringing diversity to the educational landscape in Virginia, that's bullshit. The fact that Virginia developed VWIL was not to create an all-female alternative to VMI, but was in fact a front to continue to allow its historical exclusion of women. Oh, and remember Hogan, that Supreme Court decision that any sex-based classification is subject to intermediate scrutiny? Yeah. Judge Phillips says, look, the only way that VWIL is satisfying intermediate scrutiny is if it is substantially equal to VMI, and clearly That's just not the case here. Judge Phillips said that the differences in prestige, tradition, and alumni influence alone, not even taking into consideration any of the other ways in which VWIL offers less to its students than VMI, is enough to indicate that there is no parity between these two institutions. They are not substantially equal. So, after the Fourth Circuit sides with Virginia, both Virginia and the DOJ appeal to the Supreme Court. And this time, it grants cert and, well, that's the end of our video. It's been a long one. Our next video will talk about the actual decision itself, but for now, go ahead and click the subscribe button, hit like, and make sure to drop a comment below. Love to hear what you guys think.